indeed. Now, please, can we have Fiona Murphy, King's Counsel, to open on behalf of the Category F core participants.
Good afternoon, sir. Thank you. As you know, I'm opening for TBS as well, and if it's all right, we had intended to begin with TBS, sir.
I apologise. I had overlooked that fact. Please take.
No, I don't think you were aware of it, sir. Thank you very much indeed, sir. So this statement is a significant abbreviation of the lengthy written document that we've put in on behalf of TBS. So it does not follow the structure, but none of the content is not also replicated within the written statement. So we make the statement on behalf of TBS, whose mother, Jackie, had a long-term sexual relationship with Bob Lambert. TBS was born in 1985, and his father, posing as a committed animal rights activist using the name Bob Robinson, was involved in his life until 1988, when he disappeared, abandoning TBS. And TBS did not learn of the true identity of his father for a further 24 years. And so he did not find out from the Metropolitan Police, as he ought to have done, but from his mother piecing the events together from press reports. Since then, he has been preoccupied by several aspects of his life narrative. And over the last decade, he's been looking to this inquiry for explanations and accountability. Most painfully for him, he wants to know why the Metropolitan Police Commissioner was prepared to let him live his entire life without knowledge of the true identity of his biological father, and whether there are any other children born in these circumstances who continue in ignorance. He has set out the questions that this inquiry must answer concerning the Commissioner's tolerance and or encouragement of deceptive sexual relationships, the lack of supervision and governance of the undercover officers' deployments, and the complicity of senior officers in the subterfuge aimed at protecting Bob Lambert's identity from his own son. TBS has provided powerful testimony setting out the importance to him throughout his life of learning more about his origins, the efforts he made to do so in his youth, the difficult process of reconciling himself to his biological father's absence, and the profound and traumatic impact of learning that his life was founded on deceit. You, sir, we know, will read that testimony in full. So you also have our written submission setting out the detail of why TBS complains that the treatment of him by your inquiry has not been fair, has not been consistent, has not been predictable, and has not facilitated him in being heard in relation to decisions that affect him. In this oral submission, we offer two examples only, but we align with the remarks of other core participants who've opened this week with regard to issues arising from delay and disclosure. The first example we give, sir, is the fact that the evidence of potentially pertinent witnesses has been concluded prior to TBS receiving disclosure bearing on the circumstances of Bob Lambert's deployment, his own early life, the supervisory and governance structures of the SDS, and the complicity of senior officers in the subterfuge aimed at protecting Bob Lambert's identity from him. In TBS's view, the unorthodox approach to the marshalling of evidence for a public inquiry runs the significant risk of the truth being obscured rather than eliminated by this process. Secondly, in contrast with the position in earlier phases of this inquiry, and as the issues that concern TBS come most into focus, your inquiry has made a decision to limit TBS's legal funding. His representatives have been locked out of consideration of the evidence of civilian witnesses, including the evidence of his own mother, the contentious evidence concerning the man ZWB, who it is said stood as TBS's godfather in a non-religious ceremony, and from those who have relevant evidence to offer concerning his early life, including Belinda Harvey. In this regard, he has been placed in a position of gross and unjustifiable inequity. These experiences have undermined TBS's confidence in your inquiry, sir, and he endorses the analysis of the non-state, non-police core participants' opening statement that this is an inquiry in crisis. TBS seeks reassurance that the inquiry will now take proactive steps to ensure that its dealings with him are conspicuously fair and will strive to minimise the risk of further adverse impacts upon his personal development and sense of identity, matters that will be under examination in this phase of your inquiry. So we turn next to the Commissioner's organisational responsibility, the issue that TBS has sought from the very outset to put at the forefront of the inquiry's investigation of his circumstances, including the conduct of the SDS, and most importantly, the stance of commissioners, current and past, in relation to him. TBS has outlined in his witness statement, quote, "The Metropolitan Police Service do not seem, as an organisation, to accept that in addition to planning to make sure these abuses did not happen, once they had happened, they had responsibility to try to minimise the impact, to hold their hands up, to accept that they had allowed a toxic culture to develop, which led to these issues, to acknowledge the wrongs done, and to provide resources to help the victims, such as me, to access specialist psychiatric and psychological help. It feels scary that as an organisation, the Metropolitan Police Service were happy for me to go through my whole life without knowing the true identity of my biological father. And if it were not for the work of activists and journalists, I would probably never have known the truth or had the chance to meet my biological father. The Metropolitan Police Service simply left me alone to deal with all of this, both before and after I learned of Bob Lambert's true identity." The Commissioner, in his opening statement yesterday, communicated an apology to TBS for the distress he has suffered, growing up not knowing his true parentage, for the fact that the Metropolitan Police Service should not have allowed Bob Lambert to behave in the way that he did, and committing to ensure that TBS receives answers to his questions during this inquiry. As to that apology, TBS asks you, sir, to note that while it addresses Bob Lambert's conduct, it does not address the organisational responsibility of those who knew of TBS's existence in the years and decades following his birth. And it does not address the Commissioner's own failings in relation to TBS in the period leading to and following Bob Lambert's exposure. In relation to the answers he seeks, so you will recall that at paragraph 101 of his written statement, TBS invites the Metropolitan Police Service to provide to you a corporate witness statement. We emphasise not merely a statement through lawyers, but an evidential statement, deposed in full compliance with the Commissioner's duty of candour, addressing the chronology of the organisation's awareness of, first, the developing public interest in the SDS in general, and Bob Lambert in particular. Secondly, when it became aware that there was a significant likelihood that Bob Lambert's true identity would be disclosed publicly. Thirdly, the time by which it was, or ought to have been, obvious that Bob Lambert's identity would become known to TBS. And finally, any decisions taken or explanation for the failure to make decisions regarding the need to notify Bob Lambert's identity to TBS before his mother pieced the evidence together from press reports. So TBS seeks that evidence and invites your inquiry to compel it should it not be volunteered, because of the simple fact that it was unconscionable for the Metropolitan Police Service to leave TBS and his mother to find out the truth in the manner in which they did. By maintaining the status quo, the Commissioner facilitated the grave and continuing infringement of TBS's rights, causing him irrevocable harm. And again, we invite you, sir, to consider the submissions provided as to the legal framework, and specifically the rights enshrined in statute, at common law, and in both the European Convention on Human Rights and the United Nations Convention on the Rights of the Child. Because, sir, these events did not occur in a legal vacuum. On the contrary, there have been pronouncements at the highest judicial level that the best interests of children are not served by the concealment of truth, that it is to be implied that a child such as TBS, who shows a genuine interest in his true parentage, suffers mental and psychological suffering through obfuscation of the truth, that such suffering does not diminish with age, and that the shock at discovering the truth about one's origins at a later stage will be increased by the realization that the child has been caused to believe a falsehood. That in the words of Lord Hodgson in 1972, sir, quote, "The interests of justice are best served by the ascertainment of the truth. And there must be few cases where the interests of children can be shown to be best served by the suppression of truth." The domestic and international courts have also recognised that knowledge of one's true identity positively contributes to personal development, to one's sense of self. And there are also, of course, important practical consequences, including in relation to knowledge of potential hereditary medical conditions. It follows that had the Metropolitan Police Service sought advice at the time of TBS's birth or at any stage subsequently, they would have been advised that notifying TBS of his true parentage was in his best interests. The question for your inquiry, sir, is why other considerations were permitted to prevail long after it became apparent that the truth would out. The uncomfortable reality is that it will be within this very inquiry that TBS will learn facts that ought not to ever have been obscured from him, facts regarding his childhood and early development. And it is for this reason that the restriction upon his funding attracts a special opprobrium. So you are referred to TBS's statement. You will note the tragic attempts to learn more about the fiction that was Bob Robinson, to identify with that fiction, about the efforts of his mother and grandparents to protect him from the abandonment, and how TBS has struggled to come to terms with the reality that his understanding of his parentage was based on a lie. To suppress his identification with the non-existent Bob Robinson, and to come to terms with the true identity of Bob Lambert. In his own words, quote, "The father that disappeared was a fabrication, and I've had to grapple with deconstructing that myth that my life was built around." The scale and the depth of the deception perpetrated upon TBS is truly extraordinary and deeply, deeply shocking. The impact upon TBS of this deception has been profound, and it endures to this day. I turn next to the evidence. There are aspects of the evidence as to Bob Lambert's conduct and knowledge of those facts within the SDS was summarised by counsel to your inquiry yesterday, and we do not repeat the detail this afternoon. The scope of the necessary investigation of these matters is further set out in our written statement, but we invite your careful consideration of the events in general and highlight the following. First, the role of an individual, likely a stooge, the role she played in obscuring Bob Lambert's identity and whereabouts at the time when Jackie was seeking to have TBS adopted by her new husband. A role that misled, as it was intended to do, social services and the family courts. And pausing here, we note that a privacy restriction has been imposed in relation to that individual's name. So we do not consider that preventing the publication of this name assists your inquiry in acquiring the whole truth as to those events, including most particularly the question, answers to the question, who knew? Secondly, to the extent that managers offered any advice to Bob Lambert, it appears to be to recommend that he deny the truth of his being TBS's father, a truly wicked deceit. Thirdly, not only, of course, that Bob Lambert's deployment as Bob Robinson continued for a further 3 years after TBS's birth, but that he was permitted to return in a managerial role, despite his having demonstrated in the starkest terms that his professionalism and propriety could not be relied upon, and that he posed a significant risk of ongoing harm to those among whom he was deployed. There is evidence, sir, that we ask you to consider with care that there were other children born of these abusive relationships. At a bare minimum, sir, it is the Commissioner's responsibility to assure you that no other human being is living a life with the truth obscured from him or her, as it was from TBS for more than 2 decades. There is also, sir, the evidence of a long-standing prioritisation of secrecy in relation to the nefarious activities of the SDS, even of its very existence, so as to protect the SDS and the Commissioner. We seek your close scrutiny of that aspect also. And TBS looks to this inquiry to ensure that police witnesses, whether undercover officers or managers, provide a full and complete account of events that concern him, and to ensure that there is a robust investigation of the organisational responsibility for the wrong that was done to him. So those are my remarks in respect of TBS, and if I could kindly turn now to category F. Again, sir, this oral submission is a much reduced summation of our written statement. And it's made on behalf of families whose loved ones' identities were taken by the Special Demonstration Squad and its officers. In the course of his opening statement yesterday, the Commissioner of the Metropolitan Police apologised to the families publicly for the profound impact that the use of the tactic of relying upon the identities of dead children has had on them, for the fact that the use of their loved ones' names by the SDS compounded their distress. The Commissioner acknowledged that the misconduct of officers while using the dead children's identities was disrespectful to their memories, and the Commissioner has apologised to all the families for this and for the Metropolitan Police's failure to stop that misconduct from occurring. Those remarks are, of course, welcomed. And also the Commissioner's acknowledgement that reliance was wrongly placed on the expectation that this practice would remain secret. But the striking omission is, of course, the absence of any acknowledgement that this practice ought never to have been relied upon in the first place and was never operationally justified. Not least because, as you, sir, have found, the SDS was not itself operationally justified, and that the practice of reliance on dead children's identities would have given rise to legitimate public concern and embarrassment, both to the police and to the Home Secretary, had it become known. The practice was the very antithesis of policing by consent. The Commissioner continued yesterday that he was not aware of any family of any child whose identity was used by the SDS being traced or contacted. And we invite you to put that assertion under careful evidential examination in this phase of your inquiry. What is apparent is that the risk to families from such events was never considered, although it ought to have been. And this is but one example of the SDS's deplorable myopia. As to the evidence in this phase, it will confirm to you, sir, that senior officers within the Metropolitan Police were fully aware of the practice, but did not take any steps to stop it for 2 decades, nor to close the SDS. In the context of your robust findings from Tranche 1, the families also looked to the inquiry to identify whether the assertions that there was no alternative are credible assertions, and to establish the extent of wrongdoing associated with the practice. The families also note that you reserved your findings in Tranche 1 regarding the impact of the practice, and they are grateful for the opportunity to assist with understanding of the devastation that this practice has wrought on their families, and how the memories they all cherish have been tainted and tarnished by it. Although it is very painful for them to do so, being able to speak out publicly about the practice has been a small measure in ensuring that the wider public are aware of the cost to these families, but it is an important one. Few officers turned their minds to the inevitable impact on the families, and the families express hope that through their participation in this inquiry, through their testimonies, the profound consequences of those actions will be brought to light and contribute to ensuring that the moral and ethical consequences are at the forefront of decisions made in undercover policing for the future. The families participating in this tranche, covering the period between 1983 and 1992, who had their loved ones cruelly used, are Frank Bennett and Honor Robson in relation to the abuse of their brother Michael Hartley's identity, Faith Mason in relation to her son Neil Martin, Marva and Judy Lewis in relation to their brother Anthony Lewis, and Caden Blake in relation to her brother Matthew Rayner. Each of these families have provided evidence of the devastation wrought upon them. Families that were already made vulnerable by the premature loss of a child or a young adult in the family. But those families represent only a small proportion of the victims of identity theft by the Metropolitan Police in this period. Further, in their pursuit of accountability, the families have scrutinised the practices of the undercover officers, including those who appropriated their loved ones' identities, and they looked to the inquiry to ask the questions required to bring to light how a unit at the heart of the Metropolitan Police could employ such tactics over such a prolonged period without sanction or consequence. As further explained in their written statement, the family's concern about the use of the dead children's identities does not rest with the fact of the exploitation alone, but includes understanding the extent of the intrusion into their own lives and how the identities were used. They are concerned that in taking a child's identity, the officers went on to research and use details from the family's private and family lives so as to test their identity choice and to build their legends. And they are concerned that the purposes to which the children's names were put debased their memories, and further, that not a care was given to the risks to which the families were thereby themselves exposed. As with other issues under examination in this inquiry, the family's concern, having considered the evidence, is that the inquiry is not being given the full truth, and that for the reasons set out in some detail in their written statement, there was in fact extensive intrusion into their lives as envisaged in the Tradecraft Manual. Officers did not put the dead children's identities to the service of the greater good, a phrase that we take from Caden Blake's statement. Officers went far beyond acceptable conduct, seducing women, inveigling themselves into the lives of others, attending parties and weddings, and even celebrating the birthdays of dead children as if they were their own. Officers also committed criminal offences in the names of the dead children, misled other state bodies in the process, appeared in court as witnesses or defendants in the children's names. The officers were instructed by managers to, quote, remain within the process. That is, to maintain reliance upon the dead children's identity if arrested. HN1 suggests that he was advised that the remedy for misleading the courts was to ensure that he did not, quote, lie in evidence. But he offers no commentary upon the fundamental lie as to identity. They undermined lawful and legitimate protest movements. For the Lewis family, it was especially bitter to learn about Trevor Morris's activities. In the words of Marva Lewis, it was, quote, deeply upsetting that Trevor Morris sought to undermine campaigns for racial justice while, quote, pretending to be my brother. She said that, quote, from our perspective, it seems that he had stolen the identity of a deceased young Black boy, and his work undercover contributed to undermining the investigation into the racist murder of another Black boy, Stephen Lawrence. The deplorable association of this conduct with their loved ones' names is a significant factor in their dismay that so many officers continue to enjoy anonymity, as it remains the dead child's identity with which that misconduct will be forever associated, and not the identity of the officer who was responsible for the misconduct. The families regret that they too consider it necessary to register this afternoon the disappointment with the manner in which the inquiry has engaged with them to date. Detail has been set out in their written statement, but this afternoon they emphasise one aspect only, which is that they have in substance been shut out from disclosure as to the nature and scope of the extensive restrictions that have been applied to evidence concerning the practice, and they are concerned that onerous restriction orders over historical practices are impeding the inquiry's investigations into relevant matters of importance to the families and to the future. You, sir, have directed that any attempt to challenge the restrictions, which were applied without reference to the families, is, quote, discouraged, and, quote, would almost certainly result in the existing restrictions being upheld, and that it is, quote, very unlikely that the inquiry would extend funding for the purposes of any such scrutiny. And the family's concerns are of predetermination and a conflation of the inquiry's judicial and administrative functions. The families consider that the inquiry's decision-making processes are operating to exclude them. The families do not consider that they have been placed on an equal footing to the police corps participants, nor do they consider that the open justice principle is being complied with. These problems are, of course, at their most acute in relation to the restricted family, a family who have been required to participate in this inquiry anonymously by reason of a restriction order covering their own identity, as well as that of the dead child, and the rail and cover identity of the officer. The restricted family feel silenced and disempowered by the inquiry's process, by being denied the opportunity to speak openly about the trauma they have suffered, in contrast with other families who have gained some control through being able to speak out. And the restricted family's hopes that this inquiry might expose the truth and achieve a measure of accountability have rapidly faded. In conclusion, sir, the families wish to align with counsel to the inquiry's observation that the inquiry's investigations are not a purely historical exercise. The Commissioner has now acknowledged that it was wrong to justify immoral and unlawful behaviour on the basis that they would not, quote, get found out. You, sir, are encouraged by the families to ensure that this principle extends beyond the reliance upon dead children's identities, and that undercover policing places at its core the necessity of holding itself and being held to the highest standards of propriety. It is long time since the Metropolitan Police to break the cycle of misconduct, exposure, investigation, reporting, and then a new cycle, a new form of misconduct commencing and recurring. So I'm grateful for the opportunity to address you this afternoon. Those were our remarks on behalf of TBS and the Category F families.